Hello, Internet. I'm Ben Hamilton. This is Hamilton Law, and we're here to talk about all things employment-based immigration. And today, we have to talk about this new ridiculous H-1B fee rule. Let's back it up first. You may be thinking, wait, haven't we been here before? And the answer is yes. So last September, the Trump administration issued this executive order establishing a $100K fee for an H-1B. Now, it didn't apply to all H-1Bs. It only applied to cases in which they requested what's called consular notification. Now, what it didn't apply to were changes of status. So, of course, this is ridiculous because what employer is going to pay a $100K fee in order to, employ someone who they're probably paying around $100K to begin with? What was the White House's justification for this original $100K fee? Companies were using H-1B to replace American workers. We heard that one 1,000 times. Some H-1B workers were being paid less. The program was suppressing wages. Employers were using H-1B labor even while conducting layoffs. Imposing a very high cost would discourage employers from using H-1B unless the worker was genuinely valuable. Guess what? If there's a company that was thinking about doing an H-1B and requesting consular notification, it may be one of these large IT companies that have operations in India that they're working for and have operations here. So guess what? They're likely eligible for an L-1B, maybe even an L-1A. So it doesn't even apply to them. They can get around it. So you're probably only impacting people who are doing things, quote, the right way and legitimately trying to employ H-1Bs, when the people that you think are doing it the wrong way are just going right around it, and it's not even impacting them. Anyway, what happened to this initial H-1B rule? A district court in Massachusetts held that the policy was unlawful and vacated it. So for now, DHS is not collecting these $100K fees. And of course, one of the reasons that it's unlawful is it was just done via an executive order. They didn't even go through the rulemaking process. It's called the Administrative Procedures Act. And Trump 1.0, that's why the majority of the things they did via immigration, at least employment-based immigration, got struck down, because apparently no one in the Trump 1.0 had heard about the Administrative Procedures Act. This time around, we thought they would be a little bit smarter, and in cases they were, like with the H-1B lottery rule going through the APA, so that rule stuck. Here, just executive order, bam, it got struck down. For now, of course, it's appealed, and we're going to see what happens with it. So then we enter this new rule. Oh my, is this, for lack of better words, a piece of shit? What it does is it implements a fee of $103,000 for any cap subject H-1B. It would not apply to cap exempt petitions. So think about all the people right now going to school that are on their F1. They're hoping to get their F1 OPT and then get a job and then transition from OPT to, full-time H-1B. This would effectively cut that off completely. What is the point now of coming to the U.S. to study if there's zero hope of you transitioning from F1 to some sort of work authorization? I mean, this is just stupid. How is this different from the 100K rule? Well, the most important distinction is the 100K rule only applied to cases requesting consular notification. This applies to any cap subject case, so all new H-1Bs. The other big difference is the other one was done via an executive order. This one is they're doing via the rulemaking process, so it has not taken effect yet. No one's obligated to pay it yet. Of course, the rulemaking process makes it more dangerous because it makes it more likely to stick, as opposed to the original 100K rule, which they did executive order, didn't stick. Obviously, they're trying to get this in place before March of next year, right? Because the next lottery is in March and people start applying in April. The next thing to kind of look at is what is their justification, right? Because anytime they propose a rule like this, they have to justify, well, why are we making this rule? Who's it going to help? Why are we doing it? This is where it gets interesting. So they're saying that it costs $8.78 billion per year, $3 billion to USCIS, $2.957 billion to immigration courts and EOIR, $1.21 billion to the Department of Labor. But if that's an issue, then the Department of Labor should start charging a filing fee for the LCA. $1.5 billion to ICE. What does that have to do with anything? $484 million to the State Department. Back up a second here. In order for H-1Bs to get a visa, they have to pay what's called an MRV fee, right? That's your visa appointment fee. So why are we worried about this? Again, if the fee that we're charging for the appointment's not enough, raise the fee. And then $76 million to CBP. Doesn't CBP get a budget from the government? What does this have to do with anything? So they add this up to $8.7 billion, and they divided that by 85,000 because there's 85,000 new H-1Bs each year, and that's how they got the number of 103,000. Just complete horseshit. So here's some of the things that they're saying that it would help pay for. It would help pay for the PERM program, $95 million. If the Department of Labor needs money, either they can get more from the government Or maybe they can charge a fee for every 9089 or every 9141 that's filed. They need 79 million for the H-1B program, 70 million for prevailing wages. Okay, so perms and prevailing wages are separated out. So that's the 9089 and the 9141. H-2A is 136 million. What does that have to do with H-1Bs? H-2Bs, 128 million. The wage and hour division, 350 million. The office of the solicitor, 350 million. What? In other words, an employer filing an H-1B for like a software engineer, right, which is super common, or a software developer, would be paying towards the government's cost of administrating agricultural H-2As, H-2B workers, perm cases, labor investigations, and DOL litigation. And in regards to the Department of State, it would help fund the U.S. refugee admissions program, refugee medical examinations, refugee travel. Oh my gosh, this is insane. The EOIR, nearly $3 billion would go towards the immigration court system. What? This is Congress's job to actually fund these agencies. This doesn't look like a service fee. This is a tax, right? Because they're basically saying, hey, we have all these costs over here, and we're going to make this one group over here pay for all of it. No sense whatsoever. The math ain't mathin', because when it comes to the Trump administration, they just make shit up. So why did DHS pick H-1B employers to pick on? Their basic reasoning is immigration costs need to be funded. That's Congress's job, sorry. Somebody has to pay them. Congress, other immigration applicants may have limited resources. What? The TNs are poor, so the H's have to pay for all of it? The DHS cites the median FY 2025 H-1B compensation of $133,000 per year. Then it multiplies that by the typical 6-year maximum, so they get to $798,000. Okay, so they argue that compared to a potential 6-year payroll obligation of almost $800,000, $103,000 upfront government fee is not unreasonable. This is so dumb. There's a lot of people getting paid a lot less than that. And again, this just comes back to the employer. All the Indian IT companies, they're just going to use the L-1B, right? All of the bigger companies like the Googles, the Metas, the Apples, the Amazons, they're just going to offshore this stuff, right? Because they're big enough to do that. And then all the smaller employers, they're screwed, right? They can't hire the person. Why is this math questionable? Well, first off, they didn't say basically, hey, it costs us $100,000 to adjudicate an H-1B. Okay, I might have thought that towards the beginning, but that's not what they said. Basically, what they said is, hey, we need to collect almost $9 billion, and there's these 85,000 people over here that we can just divide it amongst them, even though the overwhelming majority of this $9 billion that we're asking for has nothing to do with these people. Also, problem number 2 is, okay, so there's 85,000 potential H-1Bs, but that doesn't mean necessarily you're going to get 85,000 petitions even to begin with. In normal years, USCIS knows that of the 85,000 they select, a bunch are going to get denied, some are going to withdraw. So they actually over-select. They would actually get way more than they need. Of course, that's not going to happen. No one wants to pay that. No one's going to pay that. They're simultaneously sort of assuming that the fee won't change behavior, right? Oh yeah, we'll just slap this fee on it and all these big companies are just going to pay it. No, they're not. They're not. They're just going to offshore everybody. Don't worry, demand is so high that even at more than 100,000, there will still be at least 85,000 petitions. No, there won't. I would be surprised if there was over 5,000. That's the point. They can make all of these excuses. Oh, it's about money. No. They were looking for a justification to essentially cut off the H-1B program. Here's a fun argument. The study estimates that H-1B workers earn approximately 15 to 16% less than statistically comparable U.S. workers. And then models the savings employers may receive from hiring H-1B workers, and estimates that employers could potentially be willing to pay roughly $100,000 or more for access to an H-1B visa. Remember, they're timesing the median wage, right? Mean. They're timesing that by 6 years. But again, there's no guarantee that an employee would remain with an employer for 6 years. Why would an employer pay $100,000 when there's absolutely no guarantee that they'll get the full benefit of that 6 years? But in a world in which employees bounce around, I mean, why would you pay $100,000 and this person's with you for 6 months? It just makes no sense. So this is a contradiction, right? Because on the one hand, they're saying, oh, H-1B employers can afford this, while at the same time saying this will have a significant economic impact on 76% of small entities affected, right? So they're kind of acknowledging that, yeah, there's some big boys over here, but then there's thousands of smaller companies that hire just 1 or 2 H-1Bs. And these guys are all screwed, right? And of course, the big boys over here, they're just going to, go to the foreign entity and then maybe we'll bring you back on an L after a year. And, now the Trump administration is proposing attaching an additional 103,000, not because an H-1B costs 103,000, but because DH believes these employers are a convenient group from which to collect $9 billion a year. They will never collect $9 billion, by the way. Wait. You know what? Of course, I just realized this, but it really pisses me off is, didn't we just give like $150 billion to DHS? So why do they need this extra money? What are they doing with it? I guess they spent it all on more ICE officers with their little shock glove. Where's that money? Why are they not spending that? So what happens next, right? So, I mean, first and foremost, this has not gone into effect yet. They're actually trying to go through the process. So this is just a proposed rule that is scheduled to be published tomorrow, August 25th. There's a 30-day comment period. DHS has to review the comments. After reviewing the comments, it could make changes to the rule. It could withdraw the proposal, doubt it, or it could issue a final rule. Believe me, there's already people out there prepping litigation. If this were to go into effect, they're going to immediately, sue. The question for the court is really going to be, can DHS make 85,000 H-1B employers finance billions of dollars in unrelated immigration programs simply because DHS concludes that those employers have the greatest ability to pay? I mean, we thought the 100K fee was dead, but guess what? It might be coming back. Anyway, stay tuned to future updates, and thanks for watching.